I knew something was wrong the moment I heard the heavy machinery rumbling up the valley behind my property on that muggy Tuesday morning in June. My name is Samuel Frost, and I've owned 80 acres of pristine land in the foothills outside Boulder, Colorado for nearly 15 years. The property came with something most people around here would kill for: senior water rights dating back to 1882, giving me legal claim to the creek that ran through my land before flowing down into the valley below. That creek was not just some scenic feature. It was my lifeline, feeding my livestock, irrigating my fields, and sustaining the small ecosystem I had worked so hard to preserve. I grabbed my truck keys and headed down the dirt road that wound through my property toward the source of the noise. The sound grew louder as I approached the southern boundary, where my land bordered the new Willow Ridge subdivision that had been under construction for the past 2 years. When I crested the small hill that gave me a view of the construction site, my stomach dropped. A massive excavator was tearing into the ground, right where Boulder Creek emerged from my property and crossed into the easement that technically belonged to the county. But they were not just working in the easement. They had crossed onto my land, and they were systematically filling in the creek bed with gravel and concrete. I could see where they had already paved over nearly 200 feet of the waterway, creating what looked like a massive culvert system that redirected the flow underground. I slammed on my brakes and jumped out of my truck, running toward the construction crew. A man in a hard hat and orange vest turned to face me, his expression annoyed at the interruption. "Hey, what the hell do you think you are doing? That is my creek you are burying," I shouted over the noise of the machinery. The man held up one hand and signaled to the excavator operator to cut the engine. In the sudden quiet, he pulled out a rolled-up blueprint from under his arm. "You Samuel Frost?" he asked. "Yes, and you are trespassing on my property. That creek is protected by my water rights." He shook his head. "Actually, we have full authorization from the Willow Ridge Homeowners Association to complete this drainage improvement project. The HOA contracted us to divert the creek into a proper storm drain system that will feed the retention ponds for the subdivision. It is all legal." "Legal? You cannot just pave over a natural waterway that I have documented water rights to. Those rights are registered with the state of Colorado." The construction foreman shrugged. "Take it up with the HOA. We are just following the permits we were issued. Now, if you will excuse me, we have work to do." He turned away and signaled for the excavator to start up again. I stood there, fists clenched, watching as they continued to destroy the creek that had flowed freely across this land for centuries. I knew I needed to act fast, but I also knew that going toe-to-toe with construction workers would not solve anything. I needed to hit the HOA where it hurt, legally and financially. I drove straight to my lawyer's office in Boulder. Margaret Chen had handled my property purchase and helped me navigate various land use issues over the years. When I burst into her office and explained what was happening, her eyes widened. "Samuel, if what you are telling me is accurate, the HOA has committed a serious violation. Your senior water rights trump any permits they might have obtained from the county. Colorado water law is very clear on this." "So what do we do?" I asked. "First, we need to file an emergency injunction to stop the construction immediately. Then, we need to pull all the documentation on your water rights and determine exactly what legal standing you have. If those rights are as old as you say they are, you might have more leverage than you realize." Margaret worked through the afternoon, and by 5 o'clock, we had filed the injunction with the Boulder County Court. A judge reviewed it and issued a temporary cease and desist order that same evening. I drove back to my property with the order in hand, ready to deliver it to the construction site first thing Wednesday morning. But when I arrived at dawn the next day, the construction crew was already gone. What remained was devastation. They had worked through the night, completing their project before the legal order could stop them. The entire 200-foot section of Boulder Creek that crossed from my property into the subdivision area had been paved over, encased in concrete, and buried under 6 feet of compacted earth. The water that used to flow freely across the surface now disappeared into a dark culvert on my land and emerged nearly a quarter-mile away inside the Willow Ridge subdivision, where it fed directly into their artificial retention ponds. I stood there, looking at the destruction, and felt something cold and hard settle in my chest. They had stolen my creek. They had violated my property rights, ignored centuries-old water law, and basically given me the middle finger. But they had also made a critical mistake. They had assumed I would just roll over and accept it. I pulled out my phone and called Margaret. They finished it overnight, I told her. The creek is completely diverted into their subdivision. That complicates things, she said, but it does not change your legal rights. In fact, they may have just handed us a much stronger case. Meet me at my office in an hour. We need to talk about your options. When I arrived, Margaret had spread out a series of maps and legal documents across her conference table. She pointed to a yellowed piece of paper protected in a plastic sleeve. This is your Water Rights Decree from 1882. It gives you priority rights to Boulder Creek. In Colorado, water rights are based on the principle of first in time, first in right. Your rights predate the subdivision by over 100 years. That means you have absolute legal authority over that water. So what does that mean practically? I asked. Margaret smiled, and it was not a warm smile. It means you can shut off their water supply entirely. If they have diverted your creek to feed their subdivision without your permission, you have the legal right to reclaim that water by any means necessary, including cutting off the flow at the source. Can I really do that? Not only can you do it, but the state will back you up if they try to interfere. Colorado takes water rights extremely seriously. The subdivision has no legal claim to that water if it is flowing from your property under your senior rights. They would need to have purchased or negotiated an easement from you, which they clearly did not do. I sat back in my chair, thinking through the implications. If I cut off the water, what happens to the subdivision? That is their problem, not yours. They built their entire development around a water source they had no legal right to. Any competent attorney should have caught that during the planning phase. The fact that they did not is either gross negligence or deliberate fraud. How do I actually shut it off? Margaret pulled out another map, this one showing the topography of my property. Boulder Creek originates from a spring on your northern boundary, correct? Yes, it is fed by snowmelt and an underground aquifer. Then you need to divert the creek back to its original path or create a retention system on your property that prevents the water from reaching the culvert they built. You could dig a new channel, build a dam, or even just block the culvert entrance. As long as the water stays on your property, you are within your rights. I nodded slowly. And when the HOA comes after me? They will. And when they do, we will bury them in litigation. But Samuel, I need to warn you, this is going to get ugly. HOAs can be vindictive, especially when they realize they have made a major legal blunder. Are you prepared for that? I thought about the creek as it used to be, clear water flowing over smooth stones, supporting fish and wildlife, irrigating my pastures. Then, I thought about it buried under concrete, its course dictated by people who had no respect for the land or the law. I am more than prepared, I said. That afternoon, I rented a small excavator and brought it up to my property. I spent the rest of Wednesday and all day Thursday digging a new channel that diverted Boulder Creek away from the culvert entrance and into a large retention pond I created on the eastern section of my land. The pond would serve as a reservoir for irrigation and livestock water, keeping everything I needed on my property. By Friday morning, not a single drop of water was flowing into the Willow Ridge subdivision. I did not have to wait long for the reaction. On Friday afternoon, a white Mercedes SUV came roaring up my driveway, kicking up dust and gravel. A woman in her mid-50s climbed out, her face already red with anger. She wore expensive athleisure wear and oversized sunglasses that she ripped off as she marched toward me. "Are you Samuel Frost?" she demanded. "I am." "I am Barbara Whitmore, president of the Willow Ridge Homeowners Association. What the hell did you do to our water supply?" I leaned against my truck, arms crossed. "I reclaimed my creek, the one you illegally paved over and diverted without my permission. That water feeds our entire subdivision. We have 300 homes that depend on those retention ponds for irrigation and landscaping. You cannot just cut us off." "Actually, Barbara, I can. I have senior water rights to Boulder Creek dating back to 1882. You built your subdivision around a water source you had no legal claim to. That is not my problem." Her eyes narrowed. "We obtained all the proper permits from the county. Everything we did was legal. The county does not have authority to override state water rights. You should have done your homework before you started construction. You are going to regret this, Barbara said, her voice dropping into a threatening tone. The HOA has significant resources and very good attorneys. We will make your life a living hell. Bring it on, I replied calmly. My attorney is already prepared for whatever you want to throw at me. In the meantime, I suggest you find another water source for your subdivision, because Boulder Creek is not leaving my property anymore. Barbara stared at me for a long moment, her jaw working as if she was grinding her teeth. Then she spun around and stalked back to her Mercedes, peeling out of my driveway fast enough to spray gravel across my lawn. Margaret had been right. Things got ugly fast. The following Monday, I received a certified letter from the law firm of Patterson and Howe, representing the Willow Ridge HOA. The letter demanded that I immediately restore water flow to the subdivision and threatened legal action if I did not comply within 72 hours. It also claimed that I was in violation of county water management ordinances and could face fines of up to $10,000 per day. I forwarded the letter to Margaret, who responded with her own letter laying out my legal position and the HOA's multiple violations, including trespassing, destruction of property, and illegal water diversion. She also filed a lawsuit on my behalf, seeking damages for the destruction of my creek and demanding that the HOA restore the natural waterway at their own expense. The legal battle was officially underway. For the next 3 weeks, things remained relatively quiet on the surface, though I knew attorneys on both sides were working overtime. The subdivision's retention ponds began to dry up in the summer heat, and the once lush landscaping that had been the HOA's pride started turning brown. I heard through the grapevine that several homeowners were furious about the situation, though most of their anger seemed directed at me rather than at the HOA that had created the problem in the first place. Then came the vandalism. It started small. Someone spray-painted "Water Thief" across my mailbox. A few days later, I found nails scattered across my driveway. Then, one morning, I discovered that someone had cut through the fence on my southern boundary, allowing my cattle to wander onto the road. Fortunately, I found them before any got hit by cars, but the message was clear. The HOA or its supporters were escalating. I installed security cameras around my property and reported each incident to the Boulder County Sheriff's Department. Deputy Rick Torres took my reports seriously, especially after I explained the water rights dispute. "Sounds like you've got some angry neighbors," he said, standing in my driveway and surveying the damaged fence. "Angry HOA," I corrected. "They illegally diverted my creek, and now they are upset that I took my water back." "Well, they cannot take the law into their own hands. If they keep this up, we will start making arrests. Make sure you keep all this documentation and call us immediately if anything else happens." The harassment continued sporadically for another week, but then things took a more serious turn. On a Thursday evening in mid-July, I was in my barn when I heard the sound of heavy equipment again. My blood ran cold. I grabbed a flashlight and headed toward the source of the noise, which was coming from the area near my southern boundary. In the darkness, I could see the lights of what looked like a bulldozer working near the retention pond I had created. As I got closer, I realized with horror that someone was trying to destroy the earthwork dam I had built, attempting to reroute the water back toward the subdivision's culvert system. I immediately called 911 while running toward the machinery. "This is Samuel Frost at 4892 Mountain Creek Road. Someone is trespassing on my property with heavy equipment and destroying my water retention system." The bulldozer operator must have seen my flashlight approaching, because the machine suddenly went dark and quiet. I heard voices and the sound of people running through the brush. By the time I reached the dam, whoever had been operating the equipment was gone, but they had done significant damage. A 20-foot section of the earthwork had been torn away, and water was starting to flow through the breach toward the old culvert. Deputy Torres arrived within 15 minutes, along with 2 other officers. They examined the bulldozer, which had been abandoned at the scene. "This machine was reported stolen from a construction site in Longmont 2 days ago," Torres said after running the serial numbers. "Whoever did this came prepared." "It is the HOA," I said. "They are trying to force the water back to their subdivision." "Can you prove that?" "Not directly, but who else would benefit from this?" Torres nodded slowly. "We will investigate, but you are right that the motive points in their direction. In the meantime, you should probably repair that dam and consider hiring some security for your property. I spent all day Friday repairing the damage with help from 2 friends who ran a landscaping business. I also hired a private security company to patrol my property at night. The cost was adding up, but I was not about to let the HOA intimidate me into submission. Margaret called me that evening with news. The HOA's attorneys have filed a motion asking the court to order you to restore water flow to the subdivision. The hearing is scheduled for next Wednesday. What are our chances? Excellent. The law is clearly on your side. But Samuel, you need to be prepared for the fact that this judge might try to find some kind of compromise solution. Courts do not like situations where hundreds of families are affected, even if those families' HOA made a stupid mistake. What kind of compromise? The judge might ask you to temporarily restore some water flow while the underlying legal issues are resolved, or he might order the HOA to pay you for an easement. I will fight against anything that undermines your rights, but I wanted you to be mentally prepared. The following Wednesday, I put on my best suit and drove to the Boulder County Courthouse. The courtroom was packed with people, most of whom I assumed were Willow Ridge residents. I spotted Barbara Whitmore sitting in the front row, flanked by 2 men in expensive suits who were clearly her attorneys. Judge Raymond Fisher presided over the hearing. He was a gray-haired man in his 60s with a reputation for being fair, but no nonsense. Both sides presented their arguments. The HOA's attorneys painted me as a vindictive landowner who was depriving hundreds of families of water out of spite. They argued that the public good outweighed my individual property rights and that the court should order me to restore the water flow while a fair compensation package was negotiated. Margaret countered by laying out the clear violations the HOA had committed: trespassing, destruction of property, illegal water diversion, and now potentially criminal vandalism and theft. She presented my water rights documentation and cited Colorado case law that strongly protected senior water rights holders. She also pointed out that the subdivision had multiple alternative water sources available, including municipal water from the city of Boulder, which they were already using for drinking water. Your Honor, Margaret said, the respondents built an entire development based on a resource they had no legal right to access. They did not perform due diligence, they did not negotiate with my client, and when he exercised his lawful rights to reclaim his water, they responded with intimidation and vandalism. The court should not reward this behavior by forcing my client to give up his property rights. Judge Fisher listened carefully to both sides, occasionally asking pointed questions. When the arguments concluded, he leaned back in his chair and was silent for a long moment. This is a difficult situation, he finally said, but the law is relatively clear. Mr. Frost holds senior water rights that predate the subdivision by over a century. The HOA's failure to identify and address these rights during the planning phase is not something the court can remedy by simply ordering Mr. Frost to give up his legal entitlements. I felt a surge of relief, but the judge was not finished. However, he continued, I am troubled by the current situation where hundreds of families are facing significant hardship due to decisions made by their HOA board. Therefore, I am issuing the following order. Mr. Frost is under no legal obligation to provide water to the Willow Ridge subdivision. His water rights are confirmed and protected. However, the HOA is ordered to immediately begin negotiations with Mr. Frost for a formal water easement agreement. If such an agreement can be reached, it must be fair market value and cannot be imposed on Mr. Frost without his consent. Additionally, the HOA is ordered to restore Mr. Frost's property to its original condition, removing the culvert system and returning Boulder Creek to its natural channel, unless Mr. Frost agrees otherwise as part of a negotiated settlement. Finally, I am ordering the Boulder County Sheriff's Department to investigate the recent acts of vandalism and theft on Mr. Frost's property, with particular attention to any potential involvement by HOA, board members, or contractors. The judge's gavel came down, and the courtroom erupted in angry murmurs from the Willow Ridge residents. Barbara Whitmore's face had gone from red to almost purple. Her attorneys were already huddling with her, no doubt trying to figure out their next move. Outside the courthouse, Margaret pulled me aside. That was a good outcome, Samuel. The judge confirmed your rights and put the burden back on the HOA where it belongs. But now they are going to want to negotiate an easement. What if I do not want to give them one? That is entirely your choice, but I would suggest at least hearing what they have to offer. If the price is right and the terms protect your interests, it might be worth considering. You could name your price for the damage they have caused. I nodded slowly. I will think about it. But Margaret, I want you to make something very clear to them. I am not going to be bullied or lowballed. If they want access to my water, they are going to pay dearly for it. Understood. The following week, I received a call from Kenneth Russo, one of the HOA's attorneys, requesting a meeting to discuss a potential easement agreement. We agreed to meet at Margaret's office the next Monday. When Kenneth arrived, he was alone, except for Barbara Whitmore, who looked like she would rather be anywhere else. We sat across from each other at Margaret's conference table, and Kenneth got straight to business. Mr. Frost, my clients recognized that they made errors in how they handled the Boulder Creek situation. They are prepared to offer you fair compensation for a permanent water easement that would allow them to maintain the current culvert system and draw water for the subdivision's retention ponds. How much water are we talking about? I asked. Kenneth slid a document across the table. Based on our hydrological survey, the subdivision requires approximately 40 acre-feet of water annually to maintain the retention ponds and landscaping for the 300 homes. Margaret picked up the document and studied it. That is a substantial amount of water. What compensation are you offering? We are prepared to offer Mr. Frost $50,000 for a permanent easement, plus restoration of any damage to his property caused during the initial construction. I almost laughed. $50,000? You want permanent rights to 40 acre-feet of water per year from a senior rights creek for a one-time payment of $50,000? That is insulting. Barbara spoke up for the first time. Mr. Frost, you need to be reasonable. You are one person with more water than you could ever use. We have 300 families who need that water for their homes. Then you should have thought of that before you illegally paved over my creek, I shot back. You created this problem, not me. And now you expect me to solve it for pennies on the dollar? Kenneth held up a hand. Mr. Frost, what would you consider fair compensation? I looked at Margaret, who nodded slightly. We had discussed this possibility. First, I want full restoration of Boulder Creek to its natural state. That means removing all the concrete, grading the land back to its original topography, and replanting native vegetation. Second, I want the HOA to pay for an independent hydrological study to ensure that your diversion has not permanently damaged the creek's ecosystem. Third, I want a formal written apology from the HOA board and a public admission that they violated my property rights. And fourth, if I agree to an easement, the compensation will be $500,000 up front, plus an annual fee of $25,000 adjusted for inflation. Barbara's mouth fell open. $500,000? Are you insane? We cannot afford that. Then I guess you cannot afford my water, I said calmly. You built a 300-home subdivision. You have the money. You just did not budget for it because you thought you could steal my creek for free. Kenneth was scribbling notes. Mr. Frost, that figure is significantly higher than market rate for agricultural water rights. This is not agricultural water, Margaret interjected. This is a natural creek with senior rights that also provide significant ecological value. If you want to put a dollar figure on it, you should be calculating what it would cost the HOA to develop an alternative water source. I am guessing that drilling wells, building infrastructure, and purchasing municipal water for 300 homes would cost significantly more than what my client is asking. Kenneth and Barbara exchanged glances. We will need to discuss this with the full HOA board, Kenneth said, but I will be honest, I do not think they will agree to these terms. Then we have nothing further to discuss, I said, standing up. The judge's order stands. You need to remove your culvert system from my property and find another water source. The meeting ended shortly after that. As Margaret and I walked to our cars, she gave me a knowing look. You are playing hardball. They started this, I replied. I'm just finishing it. Be prepared for them to try other tactics. They might go to the media, try to turn public opinion against you. They might appeal the judge's decision. And there is always the possibility of more vandalism or harassment. I know, but I'm not backing down. Margaret was right about the media. The following week, a reporter from the Boulder Daily Camera called me, asking for an interview about the water dispute between me and the Willow Ridge Subdivision. I agreed, figuring it was better to tell my side of the story than let the HOA control the narrative. The article ran on the front page of the local section that Sunday. Landowner cuts off water to subdivision in rights dispute. The reporter had done her homework, laying out the facts of the case fairly, including the HOA's illegal diversion and my legal water rights. But she also included quotes from several Willow Ridge residents complaining about their dying lawns and the HOA's skyrocketing fees as they scrambled to find alternative water sources. One resident, a woman named Jennifer Martinez, was particularly vocal. Mr. Frost is being selfish and cruel. We have children who play in those parks that need water. We have elderly residents on fixed incomes who cannot afford to replace their landscaping. All he cares about is money. Reading that quote made my blood boil. I had not asked for any of this. I had not destroyed their creek or built my home on stolen water rights, but somehow I was the villain in this story. The article did bring some unexpected support, though. I received several emails and phone calls from other landowners in Colorado who had dealt with similar issues with developers and HOAs. One man, a rancher named Tom Patterson from the Western Slope, told me his story of fighting off a ski resort development that wanted to divert water from his property. "Stand your ground," Tom advised. "These developers think they can run roughshod over anyone who gets in their way. The only language they understand is legal action and financial pain. You are doing the right thing." His words bolstered my resolve, which was good because the HOA was not done fighting. In early August, they filed an appeal of Judge Fisher's ruling, arguing that he had not adequately considered the public interest and that my water rights should be subject to reasonable use restrictions. Margaret assured me the appeal was unlikely to succeed, given Colorado's strong protections for water rights, but it would delay any final resolution for months. Meanwhile, the vandalism escalated again. Someone slashed the tires on my truck while it was parked outside a feed store in Boulder. A week later, I found dead fish dumped in my irrigation pond, and someone spray-painted "selfish bastard" on the side of my barn. The security cameras I had installed caught glimpses of the vandals, but they wore masks and were careful not to show their faces. Deputy Torres and his colleagues continued investigating, but without clear evidence linking the vandalism to specific individuals, there was little they could do beyond increasing patrols in my area. Torres did tell me, though, that they were looking closely at several HOA board members and contractors who had motive and opportunity. Then, in mid-August, something happened that changed the entire dynamic of the case. I received a call from a man named David Chen, who identified himself as a homeowner in Willow Ridge. Unlike the hostile calls I'd been receiving from other residents, David sounded nervous and apologetic. "Mr. Frost, I need to speak with you in person. I have information about the HOA that I think you need to know. Can we meet somewhere private?" Intrigued and suspicious in equal measure, I agreed to meet him at a coffee shop in Boulder the next morning. David turned out to be a soft-spoken man in his early 40s who worked as an accountant. He looked uncomfortable as he sat across from me, clutching a manila envelope. "Thank you for meeting me," he said. "I want you to know that I do not support what the HOA has been doing to you. Most of us had no idea about the water rights issue until it blew up." "Okay," I said cautiously. "What did you want to tell me?" David glanced around the coffee shop, then slid the envelope across the table. "I am on the HOA board. Well, I was until I resigned last week. I have been increasingly concerned about how Barbara Whitmore has been handling this situation, so I started looking into the HOA's finances and records. What I found is pretty damning." I opened the envelope and found printouts of financial statements, emails, and what looked like contractor invoices. "Barbara knew about your water rights," David said quietly. "I found emails between her and the subdivision's developer from 3 years ago, before construction even started. The developer's attorney had flagged your water rights as a potential issue and recommended negotiating an easement with you before proceeding. Barbara's response was to bury the report and move forward anyway. She told the developer that you were just some old rancher who would not notice or care." I stared at the emails, feeling anger rising in my chest. So this was deliberate fraud. It gets worse. Barbara also hired the construction crew that paved over your creek without proper permits. She knew the county permits they had did not cover your property, but she ordered them to do it anyway and finish the job before you could stop them. That is in the emails, too. And the vandalism. David hesitated. I cannot prove she directly ordered it, but I found payments to a security company that some of us on the board had never authorized. When I asked Barbara about it, she claimed it was for subdivision protection, but I think she's been using them to harass you. There is also a payment to the owner of the construction company where that bulldozer was stolen from. It is listed as a consulting fee, but the timing is suspicious. I looked up at David. Why are you bringing this to me? Because it is wrong, he said simply. I bought my home in Willow Ridge because I thought it was a good community. But Barbara has been running the HOA like her personal fiefdom, and she has dragged all of us into this mess with her illegal actions. When I confronted her about the emails, she threatened to sue me for breaching my fiduciary duty to the HOA. That is when I resigned, but I made copies of everything first. I gathered up the documents. Thank you for this. David, I'm going to give these to my attorney. I figured you would. I just want you to know that not all of us in Willow Ridge support what Barbara has been doing. A lot of us are pretty angry that she gambled with our property values and our money to cover up her own mistakes. Margaret nearly jumped out of her chair when I showed her David's documents the next day. Samuel, this is gold. This proves that the HOA president knowingly violated your water rights and engaged in what amounts to fraud and conspiracy. We can amend your lawsuit to include these allegations, and more importantly, we can refer this to the district attorney for potential criminal charges. Will that actually go anywhere? I asked. With this level of documentation? Absolutely. Barbara Whitmore and potentially others on the HOA board could be looking at criminal charges for trespassing, vandalism, conspiracy, and fraud. The district attorney takes property rights cases seriously, especially when there is clear evidence of intentional wrongdoing. Margaret filed an amended complaint that same day and forwarded all of David's documents to the Boulder County District Attorney's Office. She also sent a copy to Kenneth Russo, the HOA's attorney, with a cover letter that basically said, "Your client has been lying to you. Here is the proof." The response was swift and dramatic. Within 48 hours, Kenneth called Margaret to inform her that his firm was withdrawing from representing the Willow Ridge HOA due to ethical conflicts. Barbara Whitmore and 2 other board members abruptly resigned. And the HOA issued a public statement saying they were conducting an internal investigation into irregularities in the handling of the water rights matter. The following week, Deputy Torres called me with an update. The district attorney is moving forward with criminal charges against Barbara Whitmore. We executed a search warrant on her home and office yesterday and seized her computer and financial records. We also arrested the owner of that security company on charges related to the vandalism on your property. He is cooperating with the investigation in exchange for a reduced sentence, and he has confirmed that Barbara hired him to harass you. What kind of charges is she facing? I asked. Right now, we are looking at criminal trespass, vandalism, conspiracy to commit theft, and possibly fraud. The DA is still reviewing everything, but it is likely there will be additional charges. This is a pretty serious case, Mr. Frost. If convicted, she could be looking at several years in prison. I hung up the phone, feeling a strange mixture of vindication and exhaustion. I'd never wanted any of this. All I had wanted was to be left alone on my property with my water rights intact. But Barbara Whitmore's arrogance and illegal actions had forced me into a battle I had not asked for. The news of Barbara's arrest made headlines in the Boulder area. The story was no longer about a mean landowner cutting off water to innocent homeowners. It was about an HOA president who had committed fraud and engaged in criminal harassment to cover up her mistakes. Public opinion shifted dramatically. I started receiving apology emails from some Willow Ridge residents who admitted they had not known the full story. A few even offered to testify on my behalf if needed. The HOA's new interim board reached out through their new attorney, asking if we could restart negotiations for a water easement. This time, when we met, the tone was completely different. The new board president, a retired engineer named Robert Williams, opened the meeting with a sincere apology. Mr. Frost, on behalf of the Willow Ridge homeowners, I want to apologize for everything you have been through. What Barbara Whitmore did was illegal and wrong, and we are committed to making this right. I appreciate that, I said carefully. Robert continued. We have reviewed your previous demands, and while the board believes the financial terms are higher than we would like, we understand that you have every right to set the price for your property and your water rights. We are prepared to accept your terms with one modification. Instead of a $500,000 upfront payment, we would like to propose a 10-year payment plan at $50,000 per year, plus the $25,000 annual easement fee. This would be more manageable for the HOA's budget without requiring a massive special assessment on the homeowners. I glanced at Margaret, who did some quick calculations on her legal pad, and nodded slightly. I can agree to that, I said, but only if the payment plan is secured by a lien on the HOA's common property and backed by a performance bond. I am not going to risk you defaulting on payments. That is reasonable, Robert agreed. We would also commit to the full restoration of Boulder Creek to its natural state, with the hydrological study you requested. The only thing we ask is that you allow us to maintain a small portion of the culvert system that directs water into our retention ponds, so we do not have to completely re-engineer the subdivision's water management. Margaret and I stepped out of the room to confer privately. What do you think? I asked her. I think this is a good deal, Margaret said. You are getting full compensation for the damage they caused, ongoing payment for the water rights, and restoration of your creek. The payment plan is secured, so your financial risk is minimal, and you are allowing them to keep part of the culvert, which is a compromise that shows reasonableness on your part. If this ever goes back to a judge, you will look like the good guy who was willing to work things out. And Barbara's criminal case? That moves forward regardless. This is a civil settlement. The criminal charges are between her and the state of Colorado. I nodded. All right. Let us do it. We returned to the conference room and spent the next 3 hours hammering out the details of the agreement. By the end of the day, we had a signed memorandum of understanding that would be formalized into a legal contract within 2 weeks. The restoration of Boulder Creek began in September. The HOA hired an environmental engineering firm to carefully remove the concrete culvert sections and restore the natural creek bed. They brought in native plants and worked with a hydrologist to ensure the creek would flow naturally while still allowing a controlled diversion to the subdivision's retention ponds. The work took nearly 2 months, but by early November, Boulder Creek looked almost like it had before the HOA destroyed it. Standing on my property and watching clear water flow over natural stones again was one of the most satisfying moments of my life. The fish had already started returning, and I had spotted a blue heron fishing in the shallows the previous week. Barbara Whitmore's criminal trial took place the following spring. I testified about the destruction of my property and the harassment I had endured. The security company owner testified about Barbara hiring him to vandalize my property. David Chen testified about the emails proving Barbara knew about my water rights and chose to violate them anyway. The evidence was overwhelming. The jury found Barbara guilty on all counts: criminal trespass, vandalism, conspiracy to commit theft, and 2 counts of fraud. The judge sentenced her to 3 years in the Colorado State prison system with the possibility of parole after 18 months. She was also ordered to pay restitution to me in the amount of $75,000 for the damage to my property and the costs of defending myself. As I walked out of the courthouse after the sentencing, Deputy Torres caught up with me. "Justice served," he said with a slight smile. "It took long enough," I replied. "But yes, justice served." The HOA made their first payment to me in December, right on schedule. I used part of the money to upgrade my irrigation systems and invest in some conservation easements on my property that would protect it from future development. The rest went into a trust fund for my grandchildren's education. Life slowly returned to normal over the following months. The security cameras stayed up and I remained cautious, but the harassment stopped completely. The new HOA board proved to be competent and reasonable, and we developed a cordial working relationship. Several Willow Ridge residents even became friends, stopping by occasionally to see the restored creek and admire the work that had been done. One warm afternoon in May, Almost exactly a year after the whole nightmare began, I was sitting on my porch when a car pulled into my driveway. I tensed for a moment, old instincts kicking in, but then I recognized David Chen getting out with his 2 young kids. "Mr. Frost, I hope you do not mind us dropping by," David called out. "My kids have been learning about watersheds and ecosystems in school, and I told them about Boulder Creek. They wanted to see it for themselves." I smiled and stood up. "Not at all. Come on, I will give you the full tour." As I walked David and his children down to the creek, pointing out the trout in the clear pools and the willows that had been replanted along the banks, I realized that something good had come out of all the conflict and struggle. The creek was protected now, not just by my water rights, but by a community that had learned the hard way about the importance of respecting property rights and natural resources. David's daughter, a bright-eyed 10-year-old named Sophie, knelt by the water's edge and watched a dragonfly hover over the surface. "It is so beautiful," she said. "I'm glad you saved it, Mr. Frost." "Me too, Sophie," I replied. "Me too." As I watched the family explore the creek that afternoon, I thought about everything that had happened: the illegal diversion, the legal battles, the vandalism, the criminal trial, and finally, the restoration and reconciliation. It had been exhausting and infuriating and expensive, but in the end, I had protected something that mattered, not just to me, but to everyone who valued clean water, healthy ecosystems, and the rule of law. Barbara Whitmore had tried to steal my creek to feed her subdivision's vanity landscaping and inflated property values. She had assumed that one landowner would not stand up to an HOA with hundreds of members and deep pockets. She had been wrong. I had pulled the water rights and cut them off, and in doing so, I had taught an entire community a lesson about respecting the law, the land, and the people who had been here long before their subdivision was even a dream in some developer's mind. The creek still flows across my property today, clear and cold and free. Every time I walk down to its banks, I remember what it took to save it, and I know it was worth every minute of the fight. The Willow Ridge subdivision continues to thrive, but now with proper respect for the water that sustains it. The annual easement payments come like clockwork, and the HOA has become a model for how to work cooperatively with neighboring landowners rather than trying to steamroll them. As for me, I am still here on my 80 acres in the Colorado foothills, watching the seasons change and the water flow. I have my cattle, my fields, and my creek, and I have the satisfaction of knowing that when powerful people tried to take what was mine, I stood my ground and won. Some folks still call me stubborn. Others say I was just greedy, holding out for money when people needed water. But those people do not understand water rights in the West, and they do not understand what it means to have something you love destroyed by people who think rules do not apply to them. I sleep well at night knowing that Boulder Creek is protected for future generations. That is worth more than any amount of money the HOA could have paid me. Though I will admit, the money does not hurt. Last month, I got a letter from the Colorado Water Conservation Board commending me for my stewardship of Boulder Creek and recognizing the restoration work that had been done. They are using my case as an example in their educational materials about water rights and environmental protection. Margaret framed the letter and hung it in her office, right next to the court order that confirmed my water rights. I never wanted to be famous or make a point. I just wanted to live peacefully on my land. But sometimes life forces you into battles you did not choose. And when that happens, you either stand up for what is right or you let the bullies win. I stood up. The creek flows. And that is all that matters. On quiet evenings, I sometimes sit by the water and listen to it moving over the rocks, the same sound that has echoed through this valley for thousands of years. It is the sound of continuity, of natural law, of something bigger and more enduring than HOA boards and subdivision politics and human greed. Barbara Whitmore is in prison, serving time for her crimes. The HOA learned a hard lesson about due diligence and respecting property rights. The homeowners of Willow Ridge learned that cheap water is not always free water. And I learned that fighting for what is right is never easy, but it is always worth it. My water rights are secure, my creek is restored, justice was served, And life goes on in the Colorado foothills, where the water still flows from the mountains to the plains, following laws far older than any court could write, sustained by rights that time and truth have made unshakable.